First case on the 9 a.m. docket for Tuesday, October 25th, 2022 is appeal number 122229, State of Kansas versus Jose Eliasar, Portillo-Ventura, Hamilton County, briefs both sides.
Good morning. May it please the court. The state appears by Jody Lipfin, present, ready for argument, and fellow Charger alumni for what it's worth.
Is that right?
Okay, Mr. Call, there's no favoritism. So,
Speaker West, class 85.
okay. Issue here.
Oh, may it please the court, Corey Call, appellate defender representing Mr. Portillo-Ventura, present, ready for argument.
I'm gonna be a little sad if we break into a Charger chant here in a few minutes, but yeah.
Well, enlightening arguments, I'm sure.
Second case on the docket is appeal number 122810, Kelly Rowe versus Phillips County Hospital, Phillips County, briefs both sides.
May it please the court, representing the plaintiff and appellant in this case, Kelly Rowe. Name is Max Couch, present and ready for argument.
May it please the court, Quentin Templeton on behalf of Phillips County Hospital, present, ready for argument.
Your Honor, that concludes the 9 a.m. docket.
Thank you, Mr. Shima. Just a couple of words of explanation for those who are visiting today, as well as those who are watching on our YouTube channel, who we welcome as well. Just to explain a little bit of what happens before we get into the courtroom. The parties have filed briefs in this matter, which the court has read. In addition, we have received the record of proceedings that occurred at the trial court level, which we call in Kansas district courts. We have reviewed portions or all of that district court record. We have also received independent research from our own staff, reviewing the arguments of the parties, and have done our own study of case law and statutes or other things that may impact the cases that we are hearing today. We will ask questions throughout. That's a way in which we can better understand the arguments that the parties have made. In doing that, we may be glancing at our computers, we're looking at our own notes, or we may be looking at cases that they are talking about, statutes that they're citing, or looking at a portion of the record. All of that's done to assist us in understanding and processing the arguments that the parties are making. So when we are doing that, we are not distracted. We are actually actively listening in that way because it does help us with our comprehension of the case. And with that, I will now call 122229 and ask the council to please come forward.
Morning, and may it please the court. Again, this state appears by Jody Lipfin this morning, and Your Honor, may I please request 2 minutes for rebuttal time?
Brandon.
Just a short summary as to how this case got before the court this morning. This was a criminal case where the defendant was convicted of rape, 2 counts of aggravated indecent liberties with a child, and an attempted aggravated indecent liberties with a child. There were 2 victims in this case. I'll use their initials, PF and CV. I believe PF at the time was 13 years old and CV was the defendant's stepdaughter and was 10 years old. At trial, both of them testified as to the touchings and to the rape charge, and the jury ultimately convicted on those 3 counts. There was also an issue, a stipulation entered into where the defendant stipulated as part of the one element of the rape, and I think of the ag indecent liberties with the child charge, he stipulated that he was over 18 years old. So there was a stipulation that was agreed to by the parties and submitted to the court, and the jury heard the stipulation where the state would have presented evidence that he was 18 years old. But I'm not entirely sure from the record, for whatever reason, defense counsel thought that would be more prejudicial for the state to present that evidence. So the stipulation was entered into and presented to the jury. The original briefs in this case were argued before the Court of Appeals, and there were three issues there. First being prosecutorial error in opening statement and in closing argument. The stipulation issue about having to have a full required jury trial waiver for the stipulation of that one element. And then a sentencing issue, which I believe the parties agreed was an error and didn't really, I mean, the state didn't contest that there was a sentencing issue. So the Court of Appeals, in their opinion, found that the opening statement prosecutorial error claim, that was prosecutorial error and reversible error. And the jury trial waiver issue for the stipulation was also reversible error. The state petitioned for review to this court on those two issues, and the defendant filed a condition or a cross petition on the other issues of prosecutorial error in closing argument. I think that sums up how we got here today. So my plan was just to kind of go in order for issues 1 and 2, the prosecutorial error and opening statement, and then get to the jury trial waiver issue. So the statement that was found to be prosecutorial error in at the Court of Appeals was made in the middle of opening statement, and it was a sentence that stated, "I will tell you right now, I believe this witness." It was in the middle of sort of a paragraph, and like I said, in the middle of opening statement. And of course, the case law tells us that prosecutors can't offer their personal opinion about the credibility of a witness. And on its own, that sentence certainly taken in isolation does.
Well, not only in isolation, how is it even in context, not an error?
And I realize I've got an uphill battle here, but I would ask the court to look at the entirety of opening statement, specifically the use of "I believe" or "I think" in the prosecutor's entire opening. I actually spoke to the prosecutor, and he said he kind of used that language he thought here as cautionary language, as "I think she's going to testify to this. I believe she's going to say this." But you
I
know,
will tell you right now, I believe this witness. That's different. And I reread the opening statement several times. He does use "I believe" a lot. And sometimes that "I believe" skirts what is allowed also. But this direct statement, how is that not error, just flat out on its face?
again, I would point the court just to look at the entirety of opening statement. And I do realize that statement on its own is problematic, but also, as the Court of Appeal noted in our brief, we did, and I suppose I am asking the court to speculate, but we did note, and so did the Court of Appeals, that this was a sentence that was awkward. It doesn't entirely make sense as written, at least in my view, or the state's view, as to the other sentences around it. So I'm not sure if it was given with that exact punctuation that, you know, "I will tell you right now, I believe this witness," because it seems unreasonable to the state, at least in our view, that you would stop this. We believe the rest of the context of opening statement is okay. He's talking about what the girls are going to testify to. He's talking about the evidence. He's talking about the order in which the touchings happen and how there could be some, you know, issues on what each victim remembers in the order. And then he just stops that entirely appropriate summation of the evidence and says, "I'll tell you right now, I believe this witness." And that's just an unreasonable reading. And I understand we have the cold record to look at, but we think it's just an unreasonable reading that he would just stop that entire opening statement.
You're not
to say
saying it's
that.
an unreasonable reading. You're saying it's a transcription error.
I'm saying I can't prove it's a transcription error, Your Honor, because we did go back and look for the recording. Apparently this trial was recorded, and I asked the prosecutor to find that recording, and we couldn't. So I can't say I don't have any evidence to prove it's a transcription error, but there are other smaller errors in the transcription,
Okay,
missing
but you're
words.
saying it's an unreasonable reading. I don't understand I mean, are you calling it an unreasonable reading of the words on the paper, or are you calling it a speculative transcription error?
Well, I don't know that I can call it a transcription error because I don't have any evidence.
How can you call it an unreasonable reading when the words on the paper?
Well, I'm just asking this court to look at it in context of the entire opening statement and to think about a prosecutor talking about what he believes or thinks the evidence is going to be, and then stopping mid-sentence and saying for one of the victims and only one of the victims that he personally believes what their testimony is going to be.
Well, what's the alternative? Are you saying he did not say those words?
I can't say that he didn't say those words. They're on the record.
I guess, I mean, that's the same question Justice Standards is asking then. You can't say he didn't say those words, then you're stuck with those words. And it
Correct.
doesn't matter. None of the context matters. He said what he said.
Well, I would disagree that none of the context matters. I think you would
Well,
have to imagine,
How does the context change the meaning of I believe this witness?
if you look at the other uses of when he said, I believe, or I think.
Well, what's a plausible alternative reading of those words? Can you offer any plausible alternative?
I just don't know if that's where the, I don't know if that's where the period goes in this sentence. I mean, I don't really have a way for it to make sense.
Well, you would, I mean, you've already acknowledged that you're on an uphill climb.
Yes.
This is a stretch argument. But you have to at least come up with a plausible alternative, don't you?
And I would go back to, I think what I put in my brief is, I think he was saying something along the lines of, I believe this witness, which is first, second, and third. The only one I think she'll be certain about is the kitchen incident. So I think he was just going to the timing of the incidents and what CV would remember. And somehow it just, I mean, that's really the best I can do, is to say somehow in the context of this, he was saying, I believe maybe she won't know which one's first, second, or third, but she's confident on the kitchen incident.
You're saying that the words, I believe this witness, in the prosecutor's mind were supposed to be followed by different words, and then he sort of lost his train of thought.
I mean, or yes, or it was just something, I'll tell you right now, I believe this witness, and then he paused as to which is first, second, and third may not know, or, something like that. So I don't know that it was a declarative. And I understand, like I said, that's what's on the page, that's what's on the cold record. And if this court reads it that way, that's what it is. But I just don't know if you can, if I agree that in the entire context of what he was doing, he says, I will tell you right now, I believe this witness, stop aside. I believe this witness, moving on to, a summation of the evidence as it was.
Let me move you over to harmless error.
Sure.
And one of the argument, and I guess two of the arguments you make, and I'll tell you right now, I think they're bad arguments.
Okay. As I'm used to up here, as I've heard before.
I'm just showing you can drop a rhetorical parenthetical into a sentence and tell you what I think, which is what I think the prosecutor did on the error side. But I do want to talk about harmless error. You make the argument that the seriousness of this error is diminished by the fact that the defense attorney didn't object and the district court judge didn't stop everything and go forward. And I thought we kind of killed that argument, those two arguments in Chandler. Why are they back here? I guess it is the Halloween season, but why are these two arguments back here, quite honestly?
My response to that, I guess, would be, in speaking with, again, with the prosecutor, if it was such a blatant and explicit personal opinion, and it was the way that the cold record says, I would expect that there would be an objection drawn. I mean, the way that reads is it's a violation and it's a prosecutorial error if that sentence is what it is. And the fact that didn't happen, I think that's worth something. I do. I think that means something because there are two other people, the judge and defense counsel, who should be looking for these types of things. And I know you don't have to object for it to be preserved, but just that kind of a blatant, explicit error, I think it is worth something that no one said anything. So was it heard in that manner, I guess?
The only case you cite to support that, because you don't have anything since Sherman or since Chandler, where again, I thought we killed these, but the only case you cite is a pre-Sherman argument. And that case specifically said that the issue was not the prosecutor vouching for the credibility of the witness. So that case doesn't seem to be applicable to the argument you're trying to resurrect. So, I mean, where are we with this?
I mean, I didn't go back and look at that case specifically, but if that's all I have, then I don't know that I can point the court to anything else.
Can I, And then I want to hear your position on the closing argument. The Court of Appeals found that it was not error, but the statement, and it's prefaced, but we know the defendant is guilty because the evidence showed you that the truth was spoken. And the only spoken words were from the two young victims. There wasn't any corroborating evidence, that sometimes not, exist in these cases. Why isn't that just kind of akin to the prosecutor saying, I know she was guilty because the girl spoke the truth? I mean, it seems to me that's what it is, but explain to me why that isn't that.
And thinking back in what I wrote in the brief initially, I believe it was just because of the context in which it was said, and that he was, that the prosecutor was talking about the evidence that was presented, talking about their testimony. And as long as it's within that context, to say, hey, I think you heard the truth. Here's what they said. Here was the evidence, tying it back to the evidence.
And
I think,
you just said, I think you heard the truth. Wouldn't that be an erroneous statement from a prosecutor to make?
if I wasn't tying it back to what testimony there was,
Obviously, you're tying it back to testimony. If you're saying about you heard, I mean, the only thing the jury hears is testimony. But it's I think you heard the truth. That's a vouching for the credibility of the state's witnesses, is it not?
I mean, yes, but we get into such, the way that people speak and say, I think, and, all of that we've talked about before. So, I mean, I guess, yes, but
Well,
tying
prosecutors
it back to
have a high duty
yes.
to provide a fair trial when someone's liberty is at stake. And so just saying, well, that's the way people talk. I mean, we have had decades of case law instructing prosecutors as to how they should talk. Doesn't strike me that that's going to win much favor, I guess. in an
I
appellate
would agree.
argument.
I mean, the most I guess I can point the court back to is context, tying it back to the evidence, because I think there can be situations where they're not talking about the evidence. And it is more emphasized than what it was in this case.
So my last question, just, I know you're out of time. If you'll presume with me that both of these statements are error, I guess I want to follow up on Justice Biles on questions on harmlessness. In a case where there's a lot of, say, physical evidence or something like that, I can see an argument maybe against harmlessness. But here, would you agree that the outcome of this trial hinged on a credibility determination of the witnesses?
Yes, we had testimony from the girls and then their forensic interview.
And that was it?
And yeah, an ID from a lineup, and I think that was all. Yes.
Given your time, I'd like to jump to Johnson and keep jumping over a lot of things in that issue and that discussion to a question of whether it can be harmless error, and look at that, jumping over the US Constitution to get to the Kansas Constitution and ask, how do we treat, or do we treat this issue any difference from a harmless error standpoint, given the Kansas Constitution statement that a right to a jury trial is inviolate? Can it be harmless error, or is it structural error given that wording of the Kansas Constitution?
I hadn't thought about it specifically for Kansas Constitution, Your Honor, but I mean, I think I would still argue that yes, harmless error could apply, because in other situations where I think I could use the same analogous situations where we're talking about the omission of an element in the crime, and we still can do a harmless error analysis for that situation, which I would find pretty similar to what we have here. So I don't know that it would be any different under the Kansas Constitution than the United States Constitution.
Or type analysis, which we have done.
Yes.
Go ahead.
Can you remind me from the record, was that element included in the instructions to the jury?
I tried to look for that last night and I didn't have the jury instructions. I think it was, but I don't I did not have the record to look at that, but I don't think they took it out. I can be corrected, but I'm not sure.
And do you think that's a relevant to the constitutional analysis?
That it was left in, yeah, I mean, I think it shows that the jury still had to make the determination of that element and consider the stipulation with the, making that determination.
How does a jury reject a stipulation? How would that happen? I mean, you say the jury can still consider it, but how does it reject stipulation by both parties that this is the evidence that will suffice beyond a reasonable? I don't understand how that's a consideration that the jury could still has to weigh.
I mean, I think if it's an element of the crime listed in the instructions and they would presume that they follow the instructions and they consider that, they might not consider that stipulation. I mean, I guess if they
Well,
didn't,
They
then
could not consider it and say you didn't prove he was over 18.
I suppose, I mean,
If a stipulation like that requires a jury trial waiver, would a jury trial waiver be required every time a defendant does not contest one element? I mean, it happens all the time. The defense says to the jury, we're not claiming that there wasn't a death here, for example. We're just saying we're not criminally liable for whatever reason. Would that require I mean, under the logic of the argument, it strikes me that we're going to have jury trial waivers all over the place.
I mean, I think that would be, yes, problematic. The stipulation though it almost seems a step further to me than just not contesting, because you're giving the jury some other, I don't want to call it a piece of evidence, but you're telling them about the stipulation, which removes the evidence. But yes, I mean, I think that could be going down that path, certainly. Problematic, and a lot more jury trial waivers would have to happen. And just to remind the court, we're at a jury trial. He had a jury trial, so.
So would you have to rely on jury nullification then? To get,
I mean, the jury could, certainly.
have to rely on that though. Does it satisfy the Kansas Constitution for that reason only?
I'm not entirely sure. I don't know.
Oh,
May it please the court. I'll answer any questions that you have. It seemed like on the procedural error, I think you covered most, but I think it's important on that. As I said, I'll certainly answer any questions about that. I guess one thing I did want to address was on the opening statement. The state argued that because it was in the opening, it was less prejudicial. And I think where I disagree with the state is I think that assumes that credibility determinations are made in closing argument, or I'm sorry, are made in deliberations. And I don't think that's true. I think the jury makes a credibility determination while the witness is testifying. And so if you have the prosecutor in opening statement saying, I'll tell you right now, I believe this witness, then when that witness comes to testify, the jury has that in their mind. When they're evaluating the story, when they're hearing that testimony, they have that in their mind. And so the subsequent instruction of the court that it's up to you to make credibility determinations has less effect. And in any event, I don't think the problem here, and that was one of the harmless error factors, is whether the jury was told that they get to make credibility determinations. And well, that's important. I don't think that's the real harm here, is that the jury, if the prosecutor says, I'll tell you, I believe this witness, that the jury is going to believe, oh, we don't have to make the determinations. The prosecutor did that. The fear is that the prosecutor, a respected member of the community, saying, I believe this witness, that is going to influence the jury when they make their own credibility determinations.
I was wondering if we shouldn't, I don't know, when I read the statement, and I probably have read it seemed to me that the prosecutor had just said, well, there are a series of incidents and and he was talking about one of the two girls. One girl doesn't remember really a couple of these incidents, but she does remember this, I think it was the second count.
Yeah.
And that's when he says, and I'll tell you, I believe her. I wonder if that his statement, which is a statement to make, touches the third rail, doesn't get muddled enough by the time you get to the end of the trial, presentation of evidence, to make an argument that it was really harmless in this case. So how would you respond to that?
I think, one, as he's talking about the witness, the jury, I think, would be very interested in, this is new information. They're trying to figure out this witness. And so I think, I believe this witness, I think that would jump out while they're talking. But more importantly than that, I think the prosecutor prefacing this with, I'll tell you right now, I believe this witness. To me, that's an attention grabber. That you're focusing, if the jury is, it's opening, this wasn't a long trial and it wasn't a long opening, but to say, I'll tell you right now, well, that grabs your attention and that focuses the jury on that. And so I think it's less likely to be muddled. And the thing is that, as I said before, it was a short trial. And as when she testified, that they would remember that this was, it filtered their perception of her testimony. And so even if you get to the end, they may not remember that he said, I believe this witness, but it filtered how they considered her testimony.
Let me push back just a little bit
Yeah.
on that. It's because of the convictions. So the prosecutor, if you take my reading of this, prosecutor's definitely putting his thumb on the scale on count 2. So I believe this witness about this, but they convicted defendant of both girls and on multiple counts beyond just the count that the prosecutor commented on. And so again, why doesn't that tell us that the impact of this statement is watered down quite a bit?
Well, I think that even if you interpret, I'll tell you right now, I believe this witness, even if there is sort of a parenthetical on this incident, even if you add that in, which is not there, I believe this witness, even if you add that in there, there's the incidents are not so distinct, are not so different factually, they're not so different contextually that you would think, well, this, if you believe that that incident happened, the other incidents seem similar to that. And I hate to make problems for myself, but I've got, as to that incident, I have a bit of a problem because he only talked about one witness, right? And he didn't say he believed PF. He said he believed CV. And the state would argue in harmless that, well, CV, the one who he's talking about, her testimony was bolstered by PF's testimony. And I would argue that because these incidents seem factually similar to each other, that the taint of that comment spreads over all of them. So my answer is that I'm not sure that when a jury is listening to testimony, is listening to a witness, that they compartmentalize each incident as far as, okay, I believe this incident, I believe that incident, I believe this witness. She said this, unless there's something, entirely different about different place, a different context, a different alibi, a different something, which isn't the case here. It was a total denial, total accusation. And so I guess I don't think that, to me, if I understand your question right, that the allegations would have to be somewhat compartmentalized to believe, well, this incident, they believe that a statement that I believe that this incident happened didn't taint all of the allegations.
Mr. Call, I'm gonna take a little bit from what Justice Biles said. Going into this, I kind of had a perception of what the transcription error argument was, but Ms. Litvin kind of narrowed that for me. when you're looking at, or when I'm looking at the comment and taking it in context, it does kind of seem like not a transcription error, that maybe the transcriptionist wrote down the wrong thing, but what the cadence of when you're talking and when there's maybe an ellipses, when you're pausing, or what does happen, because they do kind of seem like they're not complete sentence. The second incident occurs, comma, or at least we think it's the second incident in time period. I will tell you right now, I believe this witness, period. And then it starts with, which is first, second, and third. The only one I think she will be certain about is the kitchen incident. But it almost seems like there's, you know, as Justice Biles was saying, that you're talking about 3 incidents, and it seems like maybe, you know, what the comment is that she's not certain about the first or third, and that he's really focusing on, you know, the second incident. He's kind of saying, look, you know, maybe the first and third didn't even happen. And that he's focusing on the third. But what my bottom line is, what do we do with the fact that a cold transcript where a transcriptionist decides where the punctuation goes? What do we do with that? You know, because really, basically, we're talking about this sentence, which the transcriptionist decided to put in here with a period, you know, as a separate sentence, you know, with a period, that we're all up here saying, I will tell you right now, I believe this witness. And we're looking at it as an isolated sentence, that we are considering overturning an entire conviction, lots of convictions, and granting a new trial. What do we do with the fact that this could just be the transcriptionist setting apart those words and putting it in a sentence?
I think what you do, to answer your question, frankly, is you, as it's written. I think we deal with, undoubtedly, transcriptionists and court reporters, they're not perfect. They make mistakes. And it is difficult for us on appeal to know where those mistakes are. But it is perhaps one of the fictions that we live with, that this is what happened. And we can recreate the record if we can. But if we can't, this is what happened. You know, this is the history. This is what was written. And I think maybe sometimes there are obvious errors that maybe point out that maybe we can say, well, this appears to be an error. But even then, I think the remedy is to go back and you have a fact finder determine, is this what happened? And if they can't do it, I think this is the default. I think there has to be, you have to have something that says this isn't what happened. And I'm not sure this court is the one to do it. I would also point out that I think, again, I will tell you right now seems to me to be a conversational aside. It's almost something you say when you're stepping out of a train of thought. You know, so the second it occurs, at least we think it's second. I'll tell you right now, I believe this witness. Then which is first, second, third, she doesn't know. And so I don't read it as confusingly as the state did. Although when I was originally reading this and writing this, one of the problems I have is this is so bad of a statement that the inclination is, maybe this isn't right. You know, because no one would say this, but here it is. And so, but to answer your question, this is the record that we have.
Thank you.
Can you help me? One of the things I struggle with in the prejudice analysis of our legal standard is the role of the instructions and the deference we give to the jury to follow those instructions. And if you read U.S. Supreme Court precedent, it's not one that we dispose of easily. It's a strong presumption. And I assume here the instructions, if followed, would have enabled the jury to set aside those remarks. But on the other hand, there are times where that presumption is set aside, and that the precedent from the United States Supreme Court suggests that there must be some sort of indication that there was more involved, that the jury was detracted from adhering to those instructions. I guess, how do we analyze the power or the force of the instructions and when we do this prejudice analysis?
Well, I think, again, it's one of the fictions that we live in, that the jurors just follow everything. But we do step back from that some and say, well, this was too much. And I think the specific instruction that you're talking about is the instruction that it is up to the jury to make the credibility determinations. I believe that is the instruction, because that's one that the state argued.
In the
Or arguments against
statements of counsel.
Are not, are not evidence.
Right, and so I think on that, just to get, I mean, that's my broad answer. That's about as good as I can get. Specifically in this case, as far as the statements are not evidence and anything, but not evidence, so you should disregard. This isn't evidence that we're talking about. This isn't if this had been where he had said that, oh, this happened in the kitchen and it happened in the bedroom, then that's a situation where, and we're arguing that's error. Then maybe the instruction that says, we should disregard what the prosecutor said, but that's not what we're talking about here. This isn't evidence. This was a comment on credibility. And as I said before, if the problem here, it says that it's up to you to make the credibility determinations. But I don't think that cures the prosecutor statement that I believe them to. Because the jurors can make their own credibility determination. They can say, I believe that, but they can be influenced by that. And I don't, it is difficult to see how a juror would not be, that their perception of the witness would not be clouded by a statement in opening, I believe this witness. And so I think you look at the totality of circumstances, you look at, my opinion is that you read the instructions narrowly in this regard. If the prosecutor makes an error, then you look at those instructions. What exactly did this instruction say? And I don't think the instructions here cure the error. And they certainly couldn't have done it, cure the error, because they weren't given until the end of, so they couldn't have been said before, the instructions given before closing. I don't know if they have any effect on the statements in closing, but certainly not the ones in opening.
Real quickly, can we move to just the second issue? And
Yeah.
I kind of have an overall kind of global question. Came to me as we were preparing for the case, is that it seems that under our case law, we require a jury trial waiver when a stipulation is being considered to one of the elements of the offense. That's kind of the Johnson case and its progeny. And just struck me, why do we require a waiver to a jury trial to the very right that the defendant is exercising by going to jury trial? It just seems to me the inquiry of what was done here seems to satisfy part of the jury trial waiver, but the other doesn't. But the jury trial is happening. He's not waiving his right to a jury trial. So help me with that kind of quandary. It just seems strange to me that we're requiring a waiver to something he's exercising.
Yeah, as I understand it in reading, and I'm basing this mostly on Mason and Smith, which are the 10th Circuit federal cases, that a stipulation is not evidence itself. It is removing the element from the jury. It is considering that the element has been proven. So you're taking that element away from the jury, and a defendant has a right to have a jury find each and every element.
Why isn't that just evidence, though? Again, I go back to the question I asked opposing counsel. If part of the defense is, and defense lawyers do this all the time, we're not contesting, this element. We're not contesting that the victim was murdered, for example. I mean, that's an element of the crime. And it's not a written stipulation, but its effect in the trial is identical, is it not?
It is, and
wouldn't Johnson, read strictly, wouldn't Johnson require a jury trial waiver for that kind of an argument?
Two things. One, I would say, you say jury trial waivers all the time like that's a bad thing. And I don't know that that is a bad thing, as far as that before the defense enters into some sort of guilt-based defense, which I think is what we're talking about here on an element or on an entire count, that the defendant is advised that he is doing this. I'm not sure that that's a bad thing. But as I read the federal cases, and I don't know how Kansas, we're still kind of discussing this, and it may come to that, but a stipulation is fundamentally different than evidence. And they talked about, I think it was the Smith case, talked about the jury nullification and the idea that if a stipulation is merely a piece of evidence, that the jury is free to reject or accept, then the state should be able to bring in more evidence, right? I mean, if let's not use this, let's use a Johnson situation where there was a conviction for a gun. Well, if a jury can say they stipulated this, but I'm a show me kind of guy. I want to see that conviction. I think I want to see the conviction. Well, should the state be able, because you stipulate, should the state be able to bring in the conviction and show it anyway if the jury can reject that evidence? And the answer comes in the fact that stipulations aren't evidence. Stipulations are an agreement of the parties to remove that element from the consideration of the jury. The state no longer has to prove that element. And so the jury, there was one of the cases, I think it was Mason, was where the judge explicitly told the jury, you don't find these, you don't have to consider this. This has been proven. And the defendant said, whoa, that's a directed verdict on those elements. And the 10th Circuit said, no, the judge did not remove that element from the jury's consideration. The parties removed that element from the jury's consideration when they stipulated. And so I don't know if that's a difference, because I fear that I'm going to be up here arguing exactly what you're saying. But as I stand here now, that is the way the federal law is.
Under that scenario, it would matter, going back to Justice Wall's question earlier, it would matter whether or not the jury got an instruction on that element.
I don't think it would matter because I mean, I guess the
Well,
jury.
isn't that the polar opposite of the judge saying you don't have to consider this, is saying here's the instructions and you do have to consider this?
It is, but I would think that both could be proper, and just that we trust juries that if we say this element has been proven to you, then we trust that the jury is not going to nullify and go away from that. That's why we don't allow the state to present more evidence on the point.
And factually, was that element included in the instructions here?
I believe it was. I did not specifically look that up, but I perhaps am arrogant to think that I would have pointed that out if in my brief it had not been, but I believe that is the case.
Mr. Cole. All right, Ms. Litva.
May it please the court. I guess the only comment that I wrote down was just to remind the court that we did have two separate victims here, and only one comment went, or the comment in opening statement only went to CV, not to PF. And just to think about the way that their credibility was attacked during trial, and that, I mean, if we look at PF's allegations, her family and friends, I mean, she was called into a room with a bunch of adults and basically told she was lying and that she was going to go to hell for what she said. So I think if the jury can consider all of that and still find the witness to be credible, even when her own family and friends didn't believe her, that there was a large attack on her credibility. And I think that is important to point out when we're looking at the statement that was made towards just CV as opposed to PF.
Should we as appellate courts, and this includes the Court of Appeals as well, when they heard this, be asking the reversibility, the harmlessness reversibility question with respect to individual verdicts as opposed to just the verdicts? In other words, our appellate task is to determine the likelihood of the impact on the verdict. And this is an interesting case because it is maybe more clear than other cases that this particular error goes to the credibility of one witness. And so should we be asking the question, did this error impact the other convictions?
I mean, I think it's a case by case basis and here, yes, you
But
should.
no, I'm asking, should we be asking that question, period? Obviously, it's case by case, the answer to that question, but that's not typically how courts have handled the reversibility question.
I think, yes, that's true. And I think, yes, this court can be asking that question.
Did the Court of Appeals do that here?
No, I don't believe so.
It didn't, I mean, I would agree. It didn't appear
Yeah.
that they did.
I don't think that they considered that
Is that something that creates an error of law, do you think? In our appellate review standards?
not consider, I mean, let me just make sure I understand what you're asking.
You've
Your
got,
Honor.
you've
To not
got
consider,
multiple different verdicts and you've got an error. And so then the question is that error reversible? And we're supposed to ask those standard questions. We all know what they are about its impact on the verdict. But I think that courts have not sort of split that out at the lower level of, okay, are we supposed to ask its impact on each separate conviction or just the conviction as a whole? I mean, the entire case.
I mean, I think,
Understand what I'm asking?
yes, I do. I mean, I think that's what I'm asking this court to do is, hey, take this into consideration in the analysis and how does it really affect the counts that only go to, you know, the other witness's testimony when there wasn't that comment, that same sort of
Do you know
personal
of,
opinion.
do you know of any case, and did you even look, and I haven't talked this, for any case in which some convictions were reversed for prosecutorial error, but others were not?
I did not look and I cannot think of one now, but I didn't look.
And just help me kind of procedurally, these were two separate cases charged, didn't they each with each victim having a different case number? Is that right?
I believe that's correct.
And then they were consolidated for trial. Was it treated as one case at trial or was it kind of separated out? Do you recall?
From my understanding, it was treated as one case
Okay.
at trial, which is why we get into the sticky sentencing issue because they were consolidated.
Yeah.
But yes, I think they began as two separate.
And that was consolidated. And then one last point you made in your I think last paragraph of your supplemental brief, you asked the court to, on the second issue, to, I believe, if I can paraphrase, it, send it back. It doesn't matter. We don't care if you send it back if we find error because we're okay sentencing this as if the defendant was under 18. I'm paraphrasing here, but is that what you're, and one, isn't that a little late to be asking for that relief? But is that your position here, is that if we find error on the second issue, the convictions still stand, but it would be sentenced as if it's an on-grid sentence?
Yes, I think that was my point in
All right.
pointing out that there was other case law where if there was no evidence that the defendant was 18 years or older at the time of the alleged crimes, that would be the remedy to go back and just put him on grid. Now there was a departure here where he is on grid currently. So again, that's kind of where he is at the moment, but yes.
And you would agree, no one's had a chance to address, counsel hasn't had a chance to address that.
I would say my supplemental brief is a lot more thorough than what I argued in the initial one, yes.
I was thinking about, I want to get back to the threshold question of error. It occurred to me when I was sitting up here, I remembered that I did a trial back in the day where I got a mistrial based on opposing counsel's openings. It strikes me that if a motion for mistrial had been made after this prosecutor's opening statement, I can't see that it would not have been sustained. And so that's affecting my consideration of that threshold. Where am I wrong in thinking that way?
Well, Your Honor, I'm trying to think of how I'm trying to think if there was a case where there was maybe an objection and the district court, or yeah, a motion for mistrial based on prosecutorial error. And the district court got to make some kind of finding as to, you know, the way that I'm trying to think of other cases where possibly there was an argument about tone or sarcasm or
It's not
something like that.
I mean, because the prosecutor injected something that we all know the prosecutor's not allowed to put into the room, which is his opinion of witness credibility. That's just absolutely the third rail. You touch it, you die. And I realize we can then talk about the impact of this later on as the trial unfolds. But I'm just thinking that from the context of if you'd have done a motion for mistrial at the beginning, it would have been sustained, which is to tell us that that's error. And I can't get off of that. So I'm giving you the chance to get me off of that.
Sure. I guess where I was going with that, and maybe this court, maybe you won't buy this, but where I was going is, I guess, if there was a motion for mistrial and there could have been other determinations by the district court. I mean, if we're just assuming that it was, that one sentence on the page, cold record, yes, that's what we have to do here. But possibly below, there could have been more determinations made by the district court, like, oh, well, yes, he said those words, but like we were talking about the cadence or how it came in or other things like that, the district court could have said it wasn't just a standalone opinion or made some kind of facts about that. So I don't know that it would have just been, there could have been other determinations that the district court could have made, I guess.
Well, if an objection had occurred, the district court could have declared a mistrial, could have given an instruction to the jury to disregard what had just been said. It is inappropriate for counsel to comment on his own opinion unless he testifies. And so there are other things that could have been done at that moment.
I would agree,
I think
yes.
what you're trying to say is it could have been strategic that, okay, if assuming the defense counsel heard and realized the significance of that, which, they've got a lot going on too. But if they strategically decided not to object, there's still a possibility of an acquittal. And with a statement like this, if there's a conviction, we've got a good chance of getting another try at it. So it could possibly be strategic, right?
Sure, yes, I would agree with that.
But I'd like you to address what your opponent said about the effect of a taint. Taint spreads. Yes, he was only talking about this one witness, but we've got a consolidated trial here. Same defendant. What is your best argument that a taint made by this statement about one witness shouldn't spread? How are we to analyze that?
I guess I would say that the opposite, I mean, because the prosecutor was vouching, let's say, for a CF, would the jury think the opposite, that he didn't believe, or I'm sorry, CV, that he didn't believe PFs then? I mean, if that makes such an impact on what the jury believes, that the prosecutor is providing his personal opinion about one witness, would they assume that because he didn't give his personal opinion about the other witness, that the other witness is not believable?
But where do we put the needle? Where does the tie go? Does the tie go to the runner? Does the tie go to the prosecution? Does the tie go to the
Not
defense?
usually. I guess I would say that would go back to maybe my argument of where this occurred during the trial helps mitigate its effect, in that the evidence hadn't even been presented yet. The witnesses hadn't even been called to testify. So the prosecutor can say, I believe this, I'll tell you right now, I believe this witness, and the witness could get up there and the jury can look at her credibility and her body language and the way she testifies and the way that she's attacked on cross-examination and determine then if they believe her or not. And then they have all of the days of testimony, which this was a short trial. Then they also have the instructions that they're presumed to follow by the court as well, which properly stated the state's burden of proof and told the jury that statements of counsel are not, statements and arguments of counsel are not evidence. And then we had closing arguments where the prosecutor, I think both sides agreed that the prosecutor began his closing argument by telling the jury, this is up to you. It's your duty to decide whether these girls are telling the truth or not. And then ended his final closing with the same sort of comments, telling the jury that it was their duty to make those credibility determinations. So I guess I would say it doesn't spread, given that it's in the beginning of the trial and given what the jury has heard after that.
Thank you, Ms. Woodson. Thank you to both counsel for your arguments in this matter. The court will take this appeal under advisement.